Good day. I trust you are all doing well and nice and warm. Today's topic is a quick divorce possible? That is a question I receive quite often. People find certain challenges in their marriage and they want to know if I wish to divorce my spouse, how long will it take to get divorced? A quick answer would be it is possible, and the reason why it would be possible is if the parties come to an agreement regarding the divorce. If both parties are in agreement, the divorce can be finalized within a few weeks' time. And I would say the quickest possible way would most probably be in about 2.5 weeks. So let's give it about 10, 12, 13 days. That's most probably the quickest it can be done. But there are obviously various factors that are applicable. So what I'll do now is I will explain to you what are the bare minimum that needs to be attended to in order for the parties to get divorced as soon as possible and as quick as possible. And in doing so, you will also learn the requirements for a divorce. Let us begin. Number one, all divorces are not the same. In some divorces, there are minor children involved, of course. The parties will have kids. In other divorces, the parties will live in different provinces. One would live in Cape Town and the other in Johannesburg. That's also possible. And then there is the issue concerning the matrimonial property regime. How are the parties married? Are they married in community of property, whereby they share in each other's wealth and debt? Or are they married out of community property with the inclusion of the accrual regime, my apologies, or with the exclusion of the accrual regime? What does that mean? If the accrual regime is included, it means that whatever growth each party's estate had during the marriage, they would have to share in that growth, the accrual. So for argument's sake, let's say at the start of the marriage, both parties, the estates were on zero, and at divorce, the wife has an estate worth 100,000, and the husband has an estate worth 50,000. So they both grew. But because the wife's estate grew by 50,000 and more than the husband, she would have to pay the husband half that amount, and that is 25,000 rand. So that is if they were married with the accrual regime. And if they were married without the accrual regime, it would basically be out of community property. What's yours is yours, what's hers is hers, and that's it. I assume you follow what I'm saying. Those are obviously the dynamics applicable. If the parties are in agreement regarding the division of the joint estate, if they are married in community property, there aren't any issues regarding the accrual if they are married with the accrual regime. They are in agreement regarding care and contact regarding the minor children, where the children should reside, with who they should reside, with the mother, with the dad, or how they will be sharing contact every second weekend, half school holidays, or maybe a 50-50 shared care regime, where they would reside with a mother for 1 week and with a father for the next, and so on. They are in agreement regarding all these specific aspects. Then the divorce can be finalized, in my example, best case scenario, depending upon the availability of the court, service of the documentation and so on, 3 weeks maximum. So those are the different aspects that we have to look at. But how do you start the divorce? So let's deal here with a scenario of day 1 and day X regarding the ultimate divorce. Let's say you see the attorney or the advocate. Both you and your spouse comes to the advocate's office or the attorney's office, and you say we'd like to get divorced. Here is a copy of our marriage certificate, our antenuptial contract if it's applicable. We have 2 children, or we have no children, whatever the facts are, or we have adult children, that's not applicable to our scenario. And we have agreed the children will reside with this parent and the other parent will have contact. We deal with special days, Christmas, birthdays, Father's Day, Mother's Day. If the parties are Muslim, we deal with Eid and so on. The parties came to that agreement. The attorney or advocate works very fast, and they quickly, the office staff or the advocate himself, would draft a settlement agreement dealing with the property aspects. Let's say the parties are married in common property. How it should be dissolved. He or she deals with the pension fund, immovable property, if there are any, debts, deals with loans, policies and so on, but it deals with all of that in the consent paper, in the settlement agreement, and also drafts a parenting plan dealing with care and contact in a separate document quickly. Those documentation gets signed by the parties and witnessed by the office staff or whoever's there, and then immediately the advocate or attorney drafts the summons, has the summons issued at court on the same day, and to that attaches the settlement agreement and parenting plan which the party has entered into. The parties have also agreed that one would be the plaintiff and one would be the defendant, because in a divorce matter you can't have a joint divorce action. There has to be one who sues the other party for a divorce. But they came to that agreement. The wife would be the one that will be issuing the divorce, or be the plaintiff, and the husband would be the one that will be defending the divorce, or the defendant. The same day, the attorney or the advocate goes to the sheriff of the High Court to have the documentation served upon the husband. But the husband is with the attorney, so he will be at the sheriff's office in any event, and he will be served with his documentation. Wonderful. So he's served with the divorce summons. They started the process 9 o'clock in the morning. It's now lunchtime, and they have been served already. In the High Court and in many other courts, 10 days has to elapse. So we will give that 10 days to elapse. 10 ordinary days does not apply. It will have to be 10 working days. So we have to exclude weekends. So if the father, in this specific scenario, has been served on the Monday, that week has to elapse 5 days. We ignore the weekends, and another week will have to elapse. After that has happened, 10 days has elapsed, 10 working days has elapsed. Then the attorney can set the matter down on the unopposed divorce roll, because we all know the husband will be doing nothing. He will not be opposing it. He is happy with the settlement agreement the parties entered into. Once that 10 days has elapsed, the attorney sets the matter down on the unopposed divorce roll. And let's say we're dealing here with the Western Cape High Court and there's a date available in 3 days' time, because the roll closes 2 days before that. Wonderful. That's the date the attorney takes and sets the matter down for the unopposed divorce. So in our scenario, day 1 is when they met with the attorney or the advocate on the Monday. Day 10 is after the divorce. The 10 days has elapsed, which is basically 2 weeks later. And on that Monday, the attorney applies for a court date, which it would be obviously the Thursday, giving enough time. So in our scenario, we took about, let's say, 12 or 13 working days for the divorce to be enrolled on the unopposed divorce date. Now, we have a court date. The defendant done his part. He decided not to oppose the matter, of course not. Now the plaintiff would have to give testimony or evidence in court, and there are a few things that the court would obviously want to determine before the court grants a decree of divorce. Now, we look at the court roll, like what I will do in the mornings. I will make sure that my matters are on the roll, and sometimes the day before, depending upon when the roll gets published. And I see, okay, my matters on the roll, we divorces, we did 5th divorce on the roll. Wonderful. So I will ensure that my client is well prepared. So on that morning, my client will come to my office, and I would prepare him or her in my scenario, it would be the wife, the plaintiff, the lady in the specific case. Now, there are, of course, a few questions that you have to pose to the witness in order for the court to be convinced that the marriage has broken down and that the court can actually divorce you. And whatever arrangement the parties have entered into is in the minor child's best interest. Now, obviously, in this period of the last 2 weeks, the attorney would have taken the settlement agreement, the consent paper, and the parenting plan to the Office of the Family Advocate, who would, of course, look through the documentation and have endorsed it, of course. Now, you would have that document in your possession, and in the consultation, you would ask your client a few questions, or prepare your client with questions that you will pose to her on the witness stand later on that morning. So you went through the court roll and said, okay, we're number 5 on the divorce roll, and we most probably will be heard at about 11 o'clock. Okay, court starts at 10 o'clock, and that's fine. The first thing in any divorce matter that the court would want to verify and confirm is whether or not this is the plaintiff and whether or not you are married. That makes logical sense. The court cannot divorce someone who is not married, number one. And we want to verify that that is you now, the plaintiff, in the specific scenario, and that you are married to the defendant mentioned in the divorce papers. So that's the most important thing. And the third thing the court needs to verify is whether or not the court has jurisdiction to divorce you. Because you can't have a situation here whereby you live in the United States, or Gauteng for argument's sake. You live there, both parties live there, but you want to get the Western Cape High Court to divorce you. You do not live here, we do not have jurisdiction to entertain your divorce. So then the third or fourth question that will be posed is, do you categorize the Western Cape as a permanent home? Are you domiciled here? Is this your residence? Do you live here? And so on. So those are the questions that you want to verify that the court has the jurisdiction to hear this matter. Of course, you would present a true copy of your your marriage certificate. You present that as evidence, showing the court that you are married, and here is your marriage certificate. So that's very important to present. Usually that's done by showing both documentation to the witness, the plaintiff, the marriage certificate, and a copy thereof, and they will verify that that is the documentation. So the court will be convinced, or there's evidence that's presented that you are married, and we presented evidence that you live in the Western Cape, and we have jurisdiction to hear this matter. Now we'll have to deal with issue concerning the breakdown of the marriage. Now, before we do that, we should have prepared your witness, of course, with the question, of course, but also you have to determine from your witness what is the reason for the breakdown of the marriage. Now, this is a very sensitive part because you do not want to display your dirty laundry to the court and for everybody else to now know, your personal circumstances. There might have been affairs, there might have been alcohol abuse, there might have been physical abuse as well. A general answer would be just to say, that the marriage has broken down and there's no reasonable prospects of restoration thereof because of the following reasons: no love and affection, and the parties are incompatible. I think those are generally good enough reasons for the court to be convinced that the marriage has broken down. So a question you'll ask your client is, can the marriage be saved? They will say no. Are there any prospects for the restoration of a normal marital relationship? They will say no. Can you give the court reasons why? No love and affection, and we can no longer live as husband and wife, or we are incompatible, and so on. So that's where we dealt with the issue concerning the marriage. The marriage has broken down. It's an unhappy marriage, a marriage that cannot be mended, and that is reason enough for the court to divorce you based upon the marriage. Then we go further. We determine, whether or not there are minor children involved in this marriage. Has the interests of the minor children have been looked after? That's very, very important. Then we'll ask your witness, are the minor children involved? Yes. Has there been arrangements made regarding the minor children? They will say, yes, the minor child lives with me or lives with the other party, and we have come to an arrangement. And that is in the parenting plan, which will be presented a bit later on. The court at that point would be satisfied that you presented, number one, that the parties are married to each other, you presented a marriage certificate, you have presented reasons why the marriage has broken down, you've presented evidence that there are minor children involved in the specific marriage, and now we'll have to deal with the actual documentation that you would like to have to be made in order of the court. Then the next document that will be presented to the witness or the plaintiff in our scenario would be the wife, is the consent paper where the parties agreed how to divide the joint estate, because they are married incognito property in my specific example. So the pension fund would have to pay the other party half the value of the pension fund. The house will have to be sold if there's a house, and so on. And because there are minor children involved and there's a parenting plan that was entered into between the parties and which the Office of the Family Advocate endorsed, that specific document will also be presented. And basically what the witness does is the witness confirms that the document has been entered into and verifies the signatures on those specific documentation. So the clerk of the court would basically show the witness next to the signatures of the various parties, and the witness will verify that that is the signature of the husband or the specific witness. So that's quite simple. Once that has been done, the court would obviously have been presented with all the information, and hopefully the court does not have any of their own questions to pose, which is not always a good idea, because the client has been prepared to answer questions by you and not by the judge or the magistrate. I did say all goes well, the plaintiff's counsel or his attorney will basically say that's a case for the plaintiff, and if the court so pleases, we'll ask for a decree of divorce incorporating the terms of the consent paper and the parenting plan. And hopefully the court would be convinced that the marriage has broken down irretrievably, and that the documentation presented is in the minor children's best interest, and the court would grant such a decree of divorce. So that's it. That's how an unopposed quick divorce works. It's quite simple if the parties come to an agreement. If they can't come to an agreement and they are fighting with each other, and some time is required for them to resolve those specific fights, the divorce can take some time. But if the court is available and the parties are in agreement, it can take for as quick as 3 weeks, and sometimes shorter in our example. Thank you for watching, and I hope you have a lovely day.